1 minute ago, 3 separate sources with direct knowledge of activity inside Mar-a-Lago in the past 12 hours independently used the same word to describe what is happening inside the president's Florida residence right now. Panic. Not concern, not elevated tension, not strategic recalibration. Panic. The kind of panic that happens when people who believed they were protected by institutional walls discover simultaneously that the walls are thinner than they thought, that the federal grand jury that has been expanding its investigation for the past 3 weeks issued 7 new subpoenas overnight, and that at least one of those 7 subpoenas names an individual who has never previously appeared in any public account of the Iran crisis, but whose connection to the decision-making process at Mar-a-Lago goes back to the earliest planning stages of the operation that began on February 28th. I am going to give you the complete picture. The 7 new subpoenas, what they demand, who they name, why the overnight expansion represents a strategic decision by the grand jury's lead prosecutor that tells you exactly where the investigation is heading, what is happening inside Mar-a-Lago right now as the legal teams try to assess the exposure of people who thought they were peripheral to the investigation and have just discovered they are not, and what the overnight grand jury expansion means for the Supreme Court oral arguments that are now 15 days away. Subscribe right now. Federal grand juries do not expand overnight without a specific evidentiary trigger. They do not issue 7 subpoenas in a single overnight session without a finding that the evidence already collected has identified new individuals and new conduct that the original and expanded mandates did not fully reach. Something was found. Something in the existing subpoenaed materials, or in witness testimony, or in financial records obtained through the investigation's expanded financial conflict mandate, pointed the grand jury's prosecutors to 7 new individuals or entities whose connection to the Iran operation had not previously been documented in the public record. I have spent 3 decades watching federal investigations of executive branch misconduct. 7 overnight subpoenas in an already expanded investigation targeting a sitting president's inner circle is not a routine investigative step. It is a sprint to the finish line before a deadline. And the deadline the grand jury's prosecutors are sprinting toward is the Supreme Court oral argument date 15 days from now. Let me give you what I know about the 7 new subpoenas because their targets and their demands reveal the shape of the investigation's final phase more clearly than any previous development. The first 3 subpoenas target financial entities rather than individuals. Specifically, they target 3 limited liability companies incorporated in Delaware between November 2025 and January 2026, the 2-month window immediately before the Iran operation began on February 28th. Delaware LLCs are the instrument of choice for financial arrangements that require a degree of opacity because Delaware's corporate law does not require the disclosure of beneficial ownership. The grand jury is seeking the beneficial ownership records, the financial transaction records, and the communications records of 3 entities that came into existence in the 2 months before the Iran operation began. The financial conflict investigation that became part of the grand jury's expanded mandate 3 weeks ago alleged that individuals involved in the Iran operation's strategic planning held undisclosed financial interests in entities whose valuations are directly affected by global oil price movements. 3 Delaware LLCs incorporated immediately before a military operation that produced a 40 to 60% global oil price increase are precisely the kind of entities that a financial conflict investigation would identify as requiring examination. The 4th subpoena targets a private intelligence contractor whose firm has provided services to the National Security Council under a contract that was issued in December 2025, also in the 2-month window before the Iran operation began. Private intelligence contractors who receive NSC contracts immediately before a major military operation and whose work product is relevant to the strategic planning of that operation are not peripheral figures in an investigation of whether the operation's planning was infected by financial conflicts of interest. They are central figures. The 5th subpoena targets a senior aide to the president who is based at Mar-a-Lago rather than at the White House and whose role in the administration has never been publicly disclosed. The existence of a senior presidential aide operating out of Mar-a-Lago with a role sufficiently undisclosed that their name does not appear in any public account of the administration's national security structure is itself significant. Mar-a-Lago is not a secure government facility. It is a private club. Communications conducted at Mar-a-Lago about national security matters do not carry the same classification protections as communications conducted in the White House or in secure government facilities. If strategic planning for the Iran operation was conducted at Mar-a-Lago by individuals whose roles were not publicly disclosed, those communications may not be protected by the executive privilege claims the administration has been asserting over White House communications. The 6th and 7th subpoenas are the ones that have produced the most acute reaction inside Mar-a-Lago in the past 12 hours. They target two individuals who are not government officials and do not hold any formal role in the administration, but who have been present at Mar-a-Lago on multiple occasions during the period between the February 28th strikes and the current date. Both individuals have significant financial interests in the energy sector. Both individuals have documented connections to entities that have benefited financially from the 40 to 60% global oil price increase produced by the Strait of Hormuz closure. And both individuals are known to have had direct access to the president during the period when strategic decisions about the Iran operation were being made. The grand jury is investigating whether those two individuals communicated information about the operation's strategic direction to financial counterparties, who used that information to position themselves financially ahead of the oil price movements. That is not a war powers resolution investigation. That is not a concealment of diplomatic communications investigation. That is an insider trading investigation connected to a military operation. If the grand jury's financial conflict investigation has developed sufficient evidence to subpoena two private individuals with energy sector financial interests who had direct presidential access during the Iran operation's strategic planning phase, the investigation has moved into territory that no previous investigation of executive branch conduct has ever reached. Let me give you the scene inside Mar-a-Lago right now, because the panic that my sources describe is not an abstraction, and its specific character tells you something about the nature of what the overnight subpoenas have revealed to the people receiving them. Mar-a-Lago has its own legal staff. It has attorneys who are on site or on call specifically to manage the legal exposure of the president and of individuals associated with his Florida operations. Those attorneys were contacted in the early hours of this morning when the 7 subpoenas became known to the people they affect. According to two sources with knowledge of those conversations, the reaction of the Mar-a-Lago legal staff to the subpoenas targeting the two private energy sector individuals was not the calm professional assessment of routine legal exposure. It was alarm, because the subpoenas demonstrate that the grand jury has evidence connecting those two individuals to the Iran operations planning in ways that the individuals and their attorneys had not believed the investigation had reached. When people who thought they were safely outside the perimeter of an investigation discover that 7 subpoenas issued overnight have placed them inside it, the first instinct is not strategic legal planning. It is panic. And panic produces decisions that experienced criminal defense attorneys spend their careers trying to prevent their clients from making. Decisions like destroying documents, decisions like contacting potential witnesses, decisions like making financial transfers that create additional evidentiary trails. All of those decisions, made in a state of panic in the 12 hours after overnight subpoenas are received, are themselves federal crimes that can be added to the investigation's mandate. The grand jury's prosecutors know this. Overnight subpoenas in multi-defendant investigations are sometimes issued precisely because the evidentiary record suggests that the newly subpoenaed parties are likely to engage in exactly the kind of panicked obstruction that creates additional criminal exposure. I want to give you the specific legal framework that connects the insider trading theory to the existing investigation, because it is the connection that makes the overnight expansion more than an addition of new defendants to an existing case. It is a connection that potentially transforms the entire Iran investigation from a war powers and concealment case into something that resembles the most consequential executive branch corruption investigation in American history. The financial conflict investigation that became part of the grand jury's mandate 3 weeks ago alleged that individuals involved in the Iran operation's strategic planning held undisclosed financial interests in entities benefiting from oil price movements. The overnight subpoenas targeting Delaware LLCs, an energy sector contractor, and 2 private energy sector individuals with presidential access, add a new dimension to that allegation. They suggest that the financial benefit from the Iran operation's oil price effects was not merely passive, meaning that officials happened to hold interests that increased in value when oil prices rose. They suggest that the benefit may have been active, meaning that information about the operation's strategic direction was communicated to financial counterparties who used it to position themselves before the price movements occurred. Active financial benefit from non-public information about a government operation that is simultaneously causing the price movements being traded is the definition of insider trading in the government context. The relevant statute is 18 United States Code Section 1348, which prohibits securities fraud, and which has been applied to insider trading involving material non-public information about government actions in several previous cases. If the grand jury's overnight subpoenas produce evidence that the 3 Delaware LLCs, the private intelligence contractor, or the 2 energy sector individuals with presidential access, engaged in financial transactions using non-public information about the Iran operation's strategic direction, the investigation will have documented a form of executive branch corruption that is categorically more serious than any previous allegation in the case. Let me give you the implications for the Supreme Court oral arguments, because the overnight grand jury expansion arrives 15 days before the arguments, and its revelations change the political and institutional context in which the 9 justices will be deciding the war powers question. The Supreme Court's good faith finding in its most recent order established that the administration concealed material facts from the court in its emergency application. The overnight grand jury expansion, now public, adds a new dimension to the institutional context of the oral arguments. The justices will be deciding whether to validate presidential war authority in a case where the administration has been found to have misled the court, where the war authority is being exercised in a context that a federal grand jury is investigating for financial conflicts of interest and potential insider trading, and where 7 of America's closest allies have issued a formal final warning that the administration's conduct is incompatible with continued alliance membership. Those 3 contextual factors do not appear in the legal briefs. They are not part of the formal record, but they are known to the 9 justices who read the same newspapers and receive the same intelligence briefings as every other senior government official. Constitutional law does not exist in a vacuum. It is interpreted by human beings who understand the institutional stakes of the decisions they are making. The overnight grand jury expansion, visible to the entire legal and political community 15 days before oral arguments, is part of the institutional context in which those arguments will be heard and in which the decision will be made. Let me give you what I assess as the 3 most likely developments in the next 48 hours, because the overnight expansion has created a situation where multiple parties are making simultaneous decisions under pressure, and the decisions made in the next 2 days will determine whether the investigation's final phase produces additional indictments, cooperation agreements, or the kind of institutional crisis that forces a fundamental political resolution. The first development is whether any of the 7 newly subpoenaed parties contacts the grand jury's prosecutors proactively. In multi-defendant investigations at the expansion stage, the party that makes first contact with prosecutors typically receives the most favorable treatment. Every attorney advising a newly subpoenaed party knows this. The competitive logic of cooperation in a multi-defendant investigation means that the panic currently present inside Mar-a-Lago, if managed by competent criminal defense counsel, should be converting from destructive to productive, from document destruction to proactive engagement with prosecutors. Whether it is or not will be visible in the grand jury's next action. If the prosecutors receive a proactive contact in the next 48 hours, the investigation will accelerate significantly. The second development is whether General Brown makes a public statement following yesterday's leaked transcript. Brown said "no, sir" to the president in front of witnesses whose account is now public. He has not yet confirmed or denied the transcript's accuracy. His silence cannot be sustained indefinitely, and when he breaks it, the content of his statement will be the most significant public communication from an active military officer in this crisis. The third development is whether the 48-hour Allied ultimatum deadline produces a White House response. The deadline expired last night. No full briefing has been provided to the Senate Intelligence Committee. The 7 allied nations that signed the final warning are now in the decision window about whether to publish their independent assessments of the Iranian back channel. If they publish, the combination of 7 allied intelligence assessments, the leaked Situation Room transcript, the Solicitor General's supplemental brief, and the overnight grand jury expansion will constitute the most complete public documentation of an executive branch decision-making failure in American history. Subscribe now. The 48 hours following this overnight grand jury expansion are the most consequential 2 days of the Iran crisis, and every development in that window will cascade directly into the Supreme Court oral arguments 15 days from now. Tell me in the comments, do you believe the overnight subpoenas targeting private energy sector individuals with presidential access represent the investigation reaching its final evidentiary target? Or is this expansion a middle stage that will produce additional subpoenas before the Supreme Court oral arguments begin? I read every comment. My next analysis covers exactly what the 3 Delaware LLCs incorporated before the Iran operation actually contain in their financial records. What transactions occurred in the weeks surrounding February 28th, and why the pattern of those transactions is the most dangerous evidentiary development for the administration since the grand jury was first impaneled.